Chapter 8, Common Provisions. Welcome to Euro Patent Brief with Baris Atalay, where we dive deep into European patent law to make it simple and approachable. Today we're exploring EPO Guidelines, Chapter 8, Common Provisions, focusing on representation, authorizations, and procedural requirements before the European Patent Office. Let's get started. Representation 1.1 General Principles. No one is compelled to have a professional representative in proceedings before the EPO. However, here's the key exception. If you don't reside or have a principal place of business in a contracting state, you must be represented by a professional representative in all proceedings, except when filing the application or initiating the European phase. Let's pause for reflection. What does this mean? If you're outside a contracting state, a professional representative is mandatory to act on your behalf. Representation isn't just about appointing someone. It also includes filing any required authorizations. If a professional representative or legal practitioner is appointed, the EPO ensures they are duly authorized to act. Here's an example. Suppose an opponent without a representative participates in opposition proceedings, but fails to meet representation requirements. They will be asked to appoint a new representative. Without one, they'll still be informed of oral proceedings, but can't act directly before the division. 1.2 Representation by a professional representative. Only professional representatives listed with the EPO can represent you. Associations of professional representatives registered with the EPO can also act collectively for a party. If you choose to appoint an association, any member of that group can perform procedural acts, and correspondence is directed to the association. 1.3 Representation by an employee. Parties with their residence or principal place of business in a contracting state can be represented by an employee, even if the employee isn't a professional representative. However, authorizations must always be filed. 1.4 Common Representative. In cases involving joint applicants or joint proprietors, a common representative is needed. If one isn't appointed, the EPO considers the first named party as the common representative. If this isn't feasible, the EPO may request the parties to appoint one and will step in to appoint a common representative if no agreement is reached. 1.5 Representation by a legal practitioner. Legal practitioners qualified in a contracting state and authorized to act in patent matters can also represent parties. Unlike professional representatives, they aren't listed with the EPO, but are included in an internal database managed by the legal division. 1.6 Signed authorizations. Representatives must file a signed authorization if requested by the EPO. This applies to both individual and general authorizations. Authorizations remain valid until explicitly terminated, even in cases of death, unless stated otherwise. 1.7 General authorizations. A general authorization can cover multiple applications or patents and enables a representative to act across all the patent transactions of the granting party. However, general authorizations must be clearly referenced in specific cases. 1.8 Filing authorizations and consequences of noncompliance. If a representative fails to file a required authorization, procedural steps taken without it may be deemed invalid. The EPO informs parties accordingly and may grant an extension upon request. Form of documents. 2.1 Documents in a European patent application. The documents making up a European patent application, e.g., request description, claims, drawings, abstract, must meet specific physical requirements. Amendments must be typed, and handwritten changes are not accepted unless they involve symbols, formulas, or similar elements. 2.2 Replacement documents and translations. Replacement documents and translations must meet the same standards as the original application documents. 2.3 Other documents. Other documents should be typewritten or printed with a 2.5 cm left margin. Documents related to multiple applications or patents, like authorizations, require only one copy, unless specific correspondence needs to accompany them. 2.4 Filing of subsequent documents. Subsequent documents can be filed electronically using EPO's online systems, by fax or by hand. However, some items like authorizations cannot be filed via fax. During oral proceedings, documents can be submitted by email. Signature of documents. 3.1. Documents filed after the European patent application. All documents filed after submitting the European patent application must be signed by the person responsible. This includes representatives or authorized personnel. For electronically filed documents, signatures can include facsimile images, text string signatures, or enhanced electronic signatures. 3.2. Documents forming part of the application. Certain documents within the application, like the request for grant or the designation of inventor, must also be signed. Electronic signatures are acceptable for these documents. 3.3. Form of signature. Signatures must clearly identify the signing person's name and position. For legal persons, authorization to sign isn't checked unless doubt arises. 3.4. Joint applicants. For joint applicants, each must sign the request for grant or appoint a common representative. After filing, the common representative may sign subsequent documents on behalf of all applicants. Recap. Today we covered the rules of representation before the EPO and the roles of professional representatives, employees, and legal practitioners. Requirements for authorizations and consequences of non-compliance. Document standards, including signature requirements and filing methods. Thank you for joining me, Baris Atalay, on Euro Patent Brief. Stay tuned for more insights into European patent law. See you next time.